Welcome to the January webinar, Navigating the Labyrinth, Legal Compliance and Producer Background Screening in 2024 and Beyond. My name is Julie Mendel, and I'm the Education Trustee for the SILA Foundation. Before I introduce today's speakers, I have just a couple of housekeeping items. This webinar is 1 hour in length and is being recorded. For this reason, we ask that you turn your camera off and mute your microphone. Please put your questions in the chat box. We will be monitoring and posing questions to the speaker on your behalf. If we run out of time and you still have questions, we will address them via email after the webinar. Within the next week, you will receive a link to the recording and a post-webinar survey. Today, we have two speakers. Greg Kirsch, Chief Operating and Compliance Officer of Applicant Insight in No More Forms, is an industry-recognized expert in background screening solutions and compliance with the Fair Credit Reporting Act in the employment, contractor, and volunteer screening context. Greg is a former elected board member of the Professional Background Screening Association and currently chairs SILA's Agency Carrier Background Investigations Task Force. We also have Matt Braunbeck, VP of Sales at Business Information Group, also known as BIG. He has been deeply involved in the background screening industry for the better part of 23 years. In his role, Matt serves as BIG's subject matter expert on designing, implementing, and overseeing background screening programs for organizations that operate in the insurance and finance space. Over the years, he has maintained positions on both SILA and the SILA Foundation boards, and he continues to be very active in several committees. So please join me in welcoming both Greg and Matt back to our virtual webinar stage.
Yay, thank you. Okay, so, and I don't know if anyone else can see it, but I am seeing a couple of blue lines on my screen. Matt, do you see those at the bottom there? I don't. They just kind of started showing up. I don't know if it's on the admin side that something's happening, but it's not me. So I'm going to keep moving, and hopefully they go away as we proceed here. So, and they're not going away. That's unfortunate. So yeah, Mary Ellen or Julie, I'm not sure. Yeah. Oh, now I've got pink lines over here by SILA staff. I don't know if you guys can correct that, but I cannot because it is not me.
I will look into it just in case, Greg. We've never seen it before, but I'm willing to learn new things. I'll let you know.
Okay, we'll wing it. It's I have kids. I believe Matt has kids, so we're used to presenting stuff that's been colored on. So, all right. So as mentioned, my name is Greg Kirsch, and with me as always is Matt. I don't know how else to do it. No. So we are back again to talk about several different issues that are coming up within the background screening context. We're going to discuss, just for the purpose of everyone on the call, a little bit of baseline information around the FCRA and the EEOC framework. They're two separate things, but we'll just discuss that just so that we have a baseline of how some of these other things are going to come into play. We'll then go into some terms you may have heard of some clean slate laws, as well as some limited access impacts on courts. Matt specifically is going to cover some of the new fingerprinting rules for FINRA. And then we also have some content for you around adverse action based on criminal history, and then follow up with a little bit of sanctions and ongoing monitoring. So again, we're not diving really into the core of like disclosure and authorization, things like that. So many of the things we've talked about in the past. We're kind of talking about some fringe things where, and I think what's going to be different, Matt and I were talking about this before, is there's not a lot of solutions that we have on these questions right now because they're new. Any solution potentially that we might frame out could change based off of the way things are interpreted down the line. So, but we do have quite a bit of experience in some of these things, and obviously we're a good source of information as far as how different companies are handling these.
You're about whetting your appetite for things to come.
Yeah. We'll give you the real solutions maybe in 6 months once a couple of people have been litigated on this stuff. But a lot of this is pretty new. So, real quick, I would like to discuss just the Fair Credit Reporting Act. As many of you know, I could do 45 minutes on the Fair Credit Reporting Act myself. Matt could probably do a separate 45 minutes and still not cover half of what's out there. But generally speaking, when we talk about the Fair Credit Reporting Act, it's a federal law. It's been in place forever, and it basically dictates what the process is around background checks for employment permissible purpose, for volunteer screening, background check that just includes your credit for the purpose of an auto loan. It covers everything that would be considered a background check. But specifically in regards to the conversation we're having today, we're going to be talking about the roles of the Consumer Reporting Agency, or the CRA. So if you hear us say CRA, we're talking about a Consumer Reporting Agency, which is a background check entity, such as, you know, my organization and Matt's. We play that role where we go and gather information for you as an end user from a source, and then present that to you for a decision. Specifically, the clauses of the FCRA that we're going to be discussing here on CRAs is the reporting of adverse information and its limitation. So as a general rule within the FCRA, adverse information is limited to 7 years reporting. That's why when you hear something falls off your credit report after 7 years, that's why. It's the Fair Credit Reporting Act. That's the reason that stuff falls off the credit report. However, convictions are actually reportable beyond 7 years in most circumstances that we would be pondering here. And then the other responsibility on a CRA we're going to talk about is just the maintaining of procedures to ensure information is accurate, up to date, from the best possible source, things like that. Now, on end users, which this could be a carrier, it could be an employer, a contracting entity, anybody that's requesting a background check on somebody, you have a whole host of responsibilities. The primary ones for the purpose of this conversation is that you have to provide a disclosure to someone that a background report will be run. You have to collect their authorization, and you also have to notify the consumer when an adverse action may be taken. So there's something called pre-adverse and adverse in different contexts, and basically it gives them a chance to dispute something before ultimately eliminating them from that benefit.
And you know, you may look at, you know, FCRA is very broad definitions, right? It's not Fair Credit Reporting Act. It's not specific to credit reports. It's broad. Anytime you use a CRA to obtain information, there's these responsibilities that you may need to do. Now, if you go to these sources directly, the FCRA may not necessarily apply. The public record is a public record. You can go to a courthouse, you can obtain information, and that information may be used. You don't necessarily have to go through a CRA. Where the benefits of going through a CRA is there's automation and there's nationalized consolidation of programs, and you can do a lot of stuff with very little means. But you know, a lot of folks kind of ask, if we're doing things ourselves, how does that differ? And that takes a lot of the limitations of reportability, authorization, disclosure, consent. Some of that goes out the window in terms of that.
So now there's another kind of set of rules, laws, however you want to state it, that kind of runs parallel with this, and this is the EEOC guidance, specifically the guidance of 2012, which in short requires, when considering criminal history for employment or these pseudo employment type relationships, that an individualized assessment be conducted on any criminal history that you're reviewing. So that individualized assessment is, to just, review the facts and circumstances around the offense, number of offenses, age at the time of the conviction, evidence of any ability to perform work, without issue, and since the conviction, the length and consistency of employment, rehabilitation efforts, so on and so forth. The general idea behind the EEOC's guidance is that being convicted of criminal history is a barrier to maintaining future employment. Criminal history is disproportionately present within certain populations of the protected classes, and the existence of something from a long time ago doesn't have a tremendous amount of relevancy to an opportunity today if they've shown they've been able to rehabilitate. And quite frankly, the barrier to employment or earning income is a key factor in recidivism, so individuals recommitting and going back. So you have two kind of things running side by side here. You have the FCRA, which dictates the procedures around running a background check, and it dictates what a background check company can report to you, and it dictates what you generally can consider and what actions you're going to take. And then you have the EEOC guidance, which when it first came out was very focused in the employment context, but discusses just an actual review of the information versus, oh, someone checked that they had a misdemeanor from 30 years ago, I'm just not even going to interview them. That's what this was basically designed to counteract. So when you have these things coming together, now we really need to talk about how does it apply particularly to the SILA membership? How does this apply to producers? Because most of these laws would very specifically apply to captive producers because they're functionally employees and they're subject to HR and every other aspect. But when you have non-captive producers, you really have to ask, where does this bleed over? How has it changed? And you also need to consider the fact that these laws were written before the gig economy was really in play. So there was not, there wasn't, Uber and Lyft and DoorDash and all these other pseudo employment type relationships where individuals are not a direct captive employee, but they are. It is one of their primary sources, if not the primary source of income for a lot of individuals. So it has adapted the laws via their interpretation in case law, and then subsequent smaller state laws that have passed seem to inch closer and closer to covering that. So as a general rule, you want to consider anything we talk about with FCRA, employment, those two words, because employment permissible purpose is very broad under the FCRA. It could be an internship is even covered by the employment permissible purpose. You want to make sure that you consider that as, okay, this may apply to my population. We also need to consider that a lot of these laws were the jumping off point. So we're going to get into some individual state laws that took what was in the EEOC guidance of 2012 and then changed it a whole bunch. They modified this, they tweaked that, and every single state, it's like everybody's copying off of each other's tests. Like they see the one answer, and then they go in and they do the answer, but they add an additional line to make it look like they're theirs, and it's an additional line to make it look like they're theirs. So as much as federal regulatory compliance can be difficult, sometimes it's a lot easier to comply with one poorly written law that didn't ponder how it's going to be applied in the real world versus having to comply with 40, 50 individual state laws that are also poorly written, but each in their own special way. They're snowflakes. So, but again, when we talk about this, so EEOC is very specific to the use of criminal history. FCRA, though, is applicable to all background check results. So your PDB inquiries, regulatory actions, FINRA broker check, you're going to want to ask yourself, do these apply? Does the FCRA apply? If the FCRA applies, do I need to have procedures around that? If it's not FCRA, but it's still criminal history adjacent. So I don't know, FINRA broker check. I mean, Matt, you process probably more of those than I do on that side, but
Yeah.
you talk about a regulatory event. I mean, how the way those feed into it, they're derivative many times from an underlying criminal history event.
Yeah, if you just look at the various sanctions, probably the predominant sanctions in PDB and oftentimes in broker check is crime driven. They didn't admit to something on paperwork and got a sanction against them. So it's not necessarily the sanction itself, but the event that drove that sanction is now potentially contemplated here.
So, I mean, the NIPR PDB, they make it easy for you FCRA wise. They say, hey, we're FCRA. Our product is FCRA regulated because we are a third party. We're an independent private entity. We're not we're not a government entity. And we have this product that aggregates all this information from the individual states and reports it out. So there it is. PDB is FCRA covered, meaning disclosure, authorization, adverse action, all those things apply. For more on that, check the webinar catalog. We've talked about it probably 30 times in the past. It's never well received, but it is a fact. But FINRA is a government entity, so they are the source of the broker check product, so to speak, and its information. So therefore, they are not regulated under the FCRA, but arguably the EEOC here and its use on in consideration of criminal history could apply to PDB inquiries because you may have an underlying criminal history event. It could also apply to a FINRA event because there's an underlying criminal history event that led to the regulatory event. But in that same scenario, FCRA would apply to PDB but wouldn't apply to FINRA. So it's really these are all questions that you definitely want to ask. These are going to be specific to your organization and to your, as well as your background screening and producer onboarding partner as far as where these lie and what's covered in it. But we can definitely dissect some of those. And Matt, I'm trying to follow. Unless I'm not seeing it on the meeting chat, I don't see a lot of questions coming in. So, but I don't know if I'm clicking on the right thing or not over there.
No, I'm keeping an eye on it.
If anybody has any questions, please feel free to put them in the chat. I'm guessing it's the chat, and we will kind of process them as we go.
Yeah, we're keeping an eye on that, so we'll address them as we go. Don't necessarily hold them to the end because Greg and I forget what we talk about on previous slides. So.
Yeah. So I mean, there's only about 6 or 7 slides to this entire slide deck, so there should be plenty of time for questions at the end. But okay, moving on. So clean slate laws. These are basically independent of the other stuff that we just talked about, but it's a newer event. So clean slate law is basically individual states have started to pass laws that will suppress really old, what they considered to be non-significant information from the court records, from the entire court system. So it's driven by state agencies. Often the state police database is, or the Department of Public Safety or whatever it is in that state, is identifying certain things that are, and I'm going to be quite honest, most of these things are low-level drug offenses and other things like that. Because if you think about where we are as a country today, and with legalized THC, and compared to the war on drugs maybe era, where a very significant amount of what was taking place in the court system was drug related offenses, particularly misdemeanor drug offenses. They basically tried to remove some of this stuff to just further capitalize on what has what was initiated with the 2012 EEOC guidance. So they take that information, they try to they want to remove barriers to gaining employment. The states that have clean slate laws that are, I would say, notable are Utah, New Jersey, Pennsylvania, and Michigan. Michigan was most recent. This was in April. Matt and I both have plenty of stories around Michigan and its delays. So it's not always executed the best, and certain courts go down. But at the end of the day, I think what I want to drive home with the clean slate laws is these don't necessarily change the way we react as background screening entities. They don't necessarily change the way you react as employers or contractors to talent. But something you may see, and probably more often than some other industries, is rescreening. We get a lot of people that come through for rescreen upon recontracting, something like that. And so we might process the same person 5 times over the course of 10 years. If we would have run that person 5 years ago in Michigan, and maybe per the reporting guidelines and the FCRA, we were able to report a 1990 low-level misdemeanor. You run that same person post the clean slate law, that misdemeanor is not going to be there. It's just not going to be there. It's going to be very difficult for us to prove that it was or was not part of the expungement. We're just going to know it's not there. It's not there at the statewide repository, and it's not there at the county source. Now, Matt, I don't know if you want to tee off on the implementation being rocky here on this, or the nature of what is and isn't a serious crime. But
I mean, Michigan has not made a lot of great choices in terms of that. Courts being down, state repository being an option, but at a cost. inconsistencies amongst the individual court jurisdictions. It affects turnaround time, clearly. And then when, to Greg's point about some records existing and some records not existing, as a background check company, and many do, you're looking at what may have been reported in previous sessions. And, the fact that last week I found something, this week I find nothing. Well, is that a problem in process? Is it a problem in what the clerk is providing? Is it a record that's now been stricken, and is it no longer usable? And then it extends to, organizations' use of sources. When you use a consumer reporting agency, we have to go to a source, we have to go to a courthouse to obtain information, and it has to be current. Folks that are using data-based data aggregators, where their records are even further from current, could run into some challenges. We do have a question here. Are other states interested in adopting the clean slate laws? And this is something that I think we're going to see more states. Probably not fast, but we'll certainly see more states take hold of this.
Yeah, I completely agree. I mean, it's a complex task for them to undergo, because it's they have to take, Matt and I have discussed in the past some of the ways, like, the state police or state repository is just that. It's a repository. Think of it as a virtual warehouse of different court information that's funneled up to them from all the individual counties or parishes, if it's Louisiana or whatever it may be within that state. So the act of coordinating this, I mean, we have states out there, Louisiana is a perfect example, that their court system is as undigital, if that's even a word, as you can even comprehend. So the way that their information is not kind of centralized in a digital repository, I don't know how well it is tabled to even determine, okay, these are the things. I've got X million amount of records in my system, and I need to take out just these ones for these people that don't have a subsequent event and no recidivism, and they fall into these low-level things that don't involve fraud, dishonesty, assault, violence, vulnerable populations, all these other things. So whether or not we're going to, I doubt we'll see 50 state adoption, but I think, I mean, there were none, and 4 years later now there's 4. So, I mean, 1 a year, 2 a year, but they have to have generally sophisticated court systems, a state police that can identify that and report that, the state police repository report that into the counties, and then tell the counties, okay, you need to remove these 1 million case numbers from your systems, and then have them do that and have them be accountable. If it's like Michigan, certain counties will be down for months just trying to figure out how to do that, and they won't staff clerks to cover it in the interim while the systems are down. So that's where we saw delays. That's why we say it's rocky. So there's definitely lessons to be learned, but each one's going to learn their own. They're each like their own child. They're just going to learn from they'll see all their brothers and sisters make mistakes, and they're still going to make their same mistake and learn it the hard way.
Right. Well, we have a couple more questions here. Are clean slate laws different from expungements? The thought, certain crimes, even if expunged, supposed to be disclosed by an applicant. It's a good question. Depending on how a particular regulatory rule is written, an individual must disclose any criminal conviction or nolo contundere. There's a lot of different ways in which some of those regulations are written. From a reportability or existence perspective, and a truly expunged record goes away. If the individual record is expunged and done so appropriately, it will not exist in the court system. It will not exist when running a fingerprint check with the FBI or FINRA or for state licensure. So technically it goes away. And same idea with the clean slate, right?
Yeah, but at the same time, I have to emphasize, the stuff that's being removed is very low level stuff. Generally, it's considered not significant. So I haven't seen any of these clean slate laws that are removing. Well, felonies are pretty much, they can't touch felonies. Things that involve fraud, dishonesty, violence, sexual nature, domestic assault, all these other things. So, I mean, quite frankly, a lot of the stuff that I'm seeing is like, when you really think about what is the majority of like the low level crimes that are in the court system, I mean, we're talking old DUIs, misdemeanor, controlled substance, and I'm not talking about, possession of controlled substance from a year ago. I'm talking 20 years ago, 30, the 1900s, if you will. It sounds like a long time ago, but I mean, it is, it's 24 years ago. So crimes from the 1900s that are low level are, tend to be the stuff that they're trying to purge from the different systems.
There's another question here. Is there why sometimes we can't collect CRI from certain states, Michigan being an example? That's a bit, I'll say different, but sometimes very closely related. So the FBI, so anytime you run fingerprint with the FBI, whether it's directly for banking purposes, whether it's through FINRA, NFA, et cetera, the FBI doesn't own those records. They collect records for some states. They collect records frequently and store them for reporting use. In other states, it's a direct link with that particular state. So you submit fingerprints, the FBI will then ping Michigan, will ping South Carolina. The FBI doesn't have anything at all in terms of that. So they're always asking for information in a real-time fashion. And that's why sometimes when you run a fingerprint, you will get sometimes a partial record back, or the idea that they've reached out, they didn't get immediate response, and so they close the record, which then you have to automatically, you have to go and order the fingerprint record again, because you can't do anything with an incomplete result. Sometimes because you can't get a result from Michigan is simply because they're updating their system. Thus they're unresponsive, and you may not get a CRI from them specifically. That would speak to why you wouldn't necessarily get an immediate result from certain states.
What a wonderful segue. So Matt, since you're talking about fingerprinting, it just so happened to be the very next slide on this. So, oh, and yeah, look, Idaho, there's different clean slate laws. I mentioned the ones that seem to, apply recently. There are several. You're also going to see when we talk about fair chance and ban the box stuff. There's, there's some sites. There's actually a nonprofit group that tracks clean slate laws, and they have a whole bunch of states on there. The ones that I've seen that seem to affect the background check process are the four that I've mentioned so far. So sometimes there's what they're defining is a little bit different. Again, there's no single state law is the same, but I think according to that, and I'm sure I can find it, or someone can Google it, but there is a nonprofit entity that tracks that. And I want to say they said there's something like 13 states that have a clean slate law that satisfies that nonprofit's criteria of a clean slate thing. So automatic expungement of some sort. So, all right. So
as part of my segue here, there was another question about how the clean slate law affects fingerprints. Charges sometimes, even though purged, the courts still reflect on the FBI. It speaks to my comment about if it's done properly. In many instances, the subject needs to file paperwork and has to have a lawyer, a good lawyer, that files the appropriate paperwork that does the expungement. In many instances, they're told, well, it'll go away. After you reach a certain time, it'll go away. Don't worry about it. And that's not the case. And that's why they think that it's expunged at the courts, but it's still being reported in the state police system. It's still being reported up through FINRA's processing with the FBI. So that simply means the individual didn't necessarily fulfill the appropriate steps. How this clean slate works on the fingerprint front, because the state owns that record, owns that information. When the state properly removes those records, it will no longer exist when a fingerprint has been processed. So clean slate properly would be clean slate. Whether you did a public record check at a courthouse no longer exists. It won't exist when running a fingerprint either. So, some of the things that I wanted to bring up from a fingerprinting is less content of the fingerprints themselves and more so procedural. We haven't had one of these in about a year or so. And there have been kind of three segments of populations that FINRA processes that have had some changes. A couple of years ago, the FBI for channelers, those companies that can channel fingerprints to the FBI, FINRA utilizes Sterling as the channeler. To be a channeler, we have to jump through a lot of hoops. We have to, anything that the FBI says we have to maintain, we have to maintain. And one of the things in the latest channeling agreements from a year or so, a couple of years back rather, was retention of fingerprints. And so as channelers, we can only maintain fingerprints for a very short window, up to 30 days to process through processing the print, or up to 30 days, which is whichever is soonest. Because EFS providers are effectively channeling, not necessarily quote unquote channelers, but we are sending fingerprints electronically to Sterling. There's a requirement of maintenance of those fingerprints for a shorter window, because the last 2 days it takes Sterling to actually process the fingerprint record. So there are some hoops that are required of companies that can talk directly to the FBI, that can send fingerprints and records directly to the FBI. And as an extension to that, some of FINRA's rules and policies coincide with those requirements. They've made some changes from an international processing perspective, where historically EFS providers can step in and help coordinate fingerprints based on FINRA's understanding of FBI requirements. The process has to be done on a print card, on ink card. The only cards that are able to be processed through FINRA are Sterling branded cards. So anytime you have a non-US fingerprint that needs to be fulfilled, you have to obtain that fingerprint card from Sterling. That card has to be communicated with the subject overseas. That subject gets their fingerprints taken on that card, usually through local law enforcement or embassy. That fingerprint is then returned. It goes directly to FINRA for processing. So the idea of electronically capturing or organizations stepping in and digitizing fingerprints is a bit of a past. It's a little bit more of a manual process, and this is really a view on FBI requirements for FINRA. And then the more recent is the transfer agent population. So FINRA has always processed fingerprints on the security side, done so electronically. There's a whole store and forward system process around that. They've also processed fingerprints for transfer agents and other ancillary things. They did so outside of the typical securities process, because it's not regulated in the same way. They've historically done this very manual process, but they've engaged Sterling to channel those fingerprints as well, to really start to take those steps to automate that fingerprint process a little bit more for facilitation. Now, there's still some manual steps, and results still get sent back differently than on the CRD system, because FINRA bifurcates a lot of that process. But it does permit or allow open the ability for other providers like EFS providers to assist in this process, whereas you collect cards from Sterling. Those cards can be shared, or electronic fingerprints can be taken and printed onto those cards, that which is then processed with Sterling as the channeler. So a few different changes for different populations in terms of fingerprints. Does not affect content, does not affect the actual results or information that you see within the CRD system, but it does change a little bit how those prints are initially facilitated and got through the process. So there's another question here. What I find frustrating is that FINRA report showing a personal item such as a credit card debt unpaid, sued for bad debt. Items don't belong to FINRA and not indicative to the business application reviewing. Anyone else with that? Anyone have some views on that specifically? Obviously, FINRA is looking for disclosure issues, both criminal and civil. If they exist, they should be reported. They should be disclosed. But beyond that, I don't know if, from a larger audience, if anybody has some insight, drop that into Greg. I don't know if you have any insight on that.
No, I've got plenty to talk about here with adverse because we haven't even gotten into Fair Chance Acts, which is a whole nother set of laws. So
yeah, well, we'll dive into that next. And anybody who has any feedback, certainly put that into the chat.
So, adverse action and Fair Chance Acts. So I mentioned at the top of the meeting here that adverse action is just one of the requirements of the Fair Credit Reporting Act. Now, there are a host of Fair Chance Acts or Ban the Box, or they come under different names, but individual states, localities, jurisdictions have passed different laws about the use or consideration of criminal history. So you can't ask until after an offer's been made. You can't consider information that's in this time frame. When you do, you have to do X, Y, and Z. So there's a whole host of questions to consider. At the bottom here of this slide, we'll get into probably the two trickiest ones, which is California and Illinois. But generally speaking, anytime you see something about a Fair Chance Act, you're going to want to ask questions about that and how that applies to your organization. Does the law, does it apply to public employers? Does it, is it exclusive to public employers? Is it city employers? Is it all employers? Are private employers, and is it employers that are 40 or more? There's different things in every single one of these. Los Angeles has had it. New York City's had one. The list of places where it's probably shorter now to name the list of states that haven't had any type of fair chance or ban the box law applied than to go through all the ones that have something where it's either the city employers have applied to. So but the things that anytime one of these comes out, I go through and I read it and I look for specifically what type of entity is it covering, and is it covering people that are applying in that city? Is it residents of that city or that state? Is it employers in? And does it cover producers? Does it have language in there that could be interpreted to cover contract employees, producers in the carrier space? Another big one too is it housing, employment, or both? Because a lot of the Fair Chance Acts recently are specific to housing, so they don't want certain types of history should not be a barrier to an individual finding housing of some sort, because there is a whole separate conversation about tenant and rental screening, things like that. But you are not the target demo of that content. So, but the thing that really needs to be considered here is that in a lot of these state laws, they're not specific as to whether or not you're using a background check company to do it. It's just as an entity, if you're going to consider criminal history information in the application for one benefit or another, what are the steps you need to take? So even absent, remember that little triangle I kind of described of, or like the three-party system of an end user requesting a report from a background check company that then goes to a source, compiles it, and sends it back. That's a three-part chain. If you eliminate that middle party, but you're still considering criminal information, particularly criminal information, because that's what most of these apply to, There's aspects where you have to provide, you know, an individualized assessment, possibly for California, even like a secondary reassessment of any information they might happen to provide back before you take your final adverse action. And it's not technically called adverse action. So if you're using a background check company, you have pre-adverse and adverse action because you're using consumer report. If you're doing it yourself or getting it directly from a government entity of some sort, and it's public record criminal history adjacent information, how is that covered? These are all things that it's very, very difficult to answer right now. I can say, just like almost all the other laws that have passed in these different arenas, the carrier and contractor, the carrier end user slash contractor, you know, producer relationship is a little more complicated than most civil attorneys want to go after, because they don't understand it and they're not going to take the time to understand it. They'd much rather see, you know, uh, they'd rather file a class action against Home Depot for some technical violation for everybody that's ever applied. It's easier for them than to understand the complexities of the insurance and securities industry. But, you know, I cannot tell you, I can't look anybody, you know, in the SILA membership in the eye and say that I can't make an argument that particularly the most recent law in California in 2023 is not arguably applicable to non-captive producers and 100% applicable to your captive producer population. So in turn, there's a lot of conversations about that. Matt, you've probably had very similar conversations.
Yeah, absolutely. One item I want to point out, the employer location. So if you're, broadly defining, employment, and it includes contractors, and when you look at employer location or where the individual is to be employed, what does that mean from an appointment perspective? You have an agent that's being appointed in California, lives in Illinois. And you're denying them because they had business in California. It was just in time. And at what point does this now fall, under that purvey? So for the source, doesn't matter. Does that mean fingerprinting? You're running fingerprinting. A disclosure issue was uncovered. You now have to take action on that. At what point does this now fall, under that requirement? So it's a lot of changes. And to Greg's point earlier, it would be make much more sense if there was some federal law that drove all of this, no matter how poorly written as it was. But the idea that it's not even states, we're looking at New York City. And employment.
Los Angeles. Does Los Angeles's fair chance law become moot now that California passed their own statewide fair chance law? Or now, if you have someone that's in Los Angeles, do you have to apply the Los Angeles process, a California state process, and if you're using a background screening company, the federal FCRA process? So, I mean, how many letters are you going to inundate this person with before, it's very convoluted, and it's very much a wait and see. A lot traditional employers have gone ahead and applied certain infrastructure to support this. On the contract labor side, I'm not seeing it adopted so much, and it's kind of a wait and see of well, what's the real interpretation here, and do we cover, or are we covered in it? And it kind of comes, I mean, this is the California law. Again, it's the most recent. It's probably the most demanding of the laws, just because it seems to walk almost like in a parallel universe to the FCRA, where there's certain steps that are in place, but if they're merging together, and it's just like an overlap. But this is how the new California Fair Chance Act defines an employer, which is basically an entity that would have to basically adopt this process or not. Does it cover, as a carrier, your non-captive producers? I don't know.
There's no answer. But we already said we're not going to give answers today.
Yeah,
right?
yeah. I mean, I can argue includes a labor contractor. So are you a labor contractor or an entity that provides contract? I don't know. It's, again, navigating individually poorly written laws is so much harder than navigating, one collective poorly written law. But
in this risk adverse industry that we're in, insurance, financial services, there's a lot of organizations that are belt and suspenders, and we're going to apply it across the board because we've got multiple distribution levels, and we want to make sure we're meeting it on all fronts. Versus those that just want to keep as far away from these as possible. They don't want anything considered employment with the relationship of the agents, for fear of all of these other employment requirements following suit. So individual assessments across the board for organizations, and depending on your risk threshold, which directions get applied.
So what can you do? And again, this is just summarizing something. We do have one more slide about monitoring, but I do want to mention, as far as things you can do, a lot of this is talk to your lawyer. But one thing you can do is limit conviction reporting history. So for instance, the less things that are being reported to you by your background check company, the less things that are arguable to fall under that event. So again, you're talking risk mitigation. There's the risk of, well, if I don't know about it, is it going to threaten my business? But then there's also the risk of, do you know about it and you probably shouldn't have known about it, or because now you have to take these steps and you don't have the infrastructure to take the steps. So just one thought for is whether or not you want to remove misdemeanors beyond 7 years. Because again, why assume the risk of the state compliance of something like that when you're probably not going to use that in a decision. And based off of EEOC guidance and stuff, you arguably shouldn't, depending on the nature of business and some other circumstances. Otherwise, as each one of these states passes something else, you have to ask yourself, are you present or active in that state? Are the captive producers covered by that state's law based on the way it's written? And are your non-captive producers covered in that state's law? Those are questions that really, self-proclaimed experts like Matt and myself are always there to tell you, without naming names, that what we see other entities doing and how they're adapting to it. But if you're asking me how other entities are adapting to it on day one of the law's effective date, they don't really know. Everyone's kind of figuring it out at the same time. So monitoring, now that's a whole nother, there's monitoring, and because we talked about the PDB and we talked about FINRA, but there's a bunch of other sanctions monitoring products out there that many of you use. And if you're in the Medicare space, or you have some type of HHS, OIG, GSA monitoring, sometimes it's through a CRA, sometimes you have an entire team that just runs that stuff once a year on all the population. So are you doing it yourself? Are you running it through a different entity? But with those, the same thing's going to apply here. If it's through a background screening company, all the FCRA stuff would apply. Do you have a release on file? All that stuff. If you're doing it yourself, do you have California procedures? Are you doing it on California residents? Do you have a California book of business that these individuals are applied to? And is it criminal history? Again, you could have an individual could have a criminal history event that ultimately results in a Medicare sanction or some other thing, some fraud, something like that. So it's criminal history adjacent. So those are, again, they're all things that you have to ask. So whether or not you're doing, it's not just your standard background check, your onboarding or upon renewal or licensing type background check thing. It's all the stuff that exists afterwards too. These state laws don't ponder the difference between you doing it yourself and versus a CRA. And I'm sorry, go ahead, Matt.
I have not seen any questions lately. So certainly if anything struck you on the last few slides, I know we threw out a lot of things to ponder and consider. if there's, any questions that we can kind of collectively talk through, mull over as a larger audience, certainly pose them for us. I think this was our final slide. Yes.
Oh, you see, Matt, I snuck one in and you didn't even know it since our last review.
look at that.
I got some housekeeping here for everyone.
All
So,
right.
it's just some very quick housekeeping. The Consumer Financial Protection Bureau, which governs the FCRA, they issued an updated summary of rights under the FCRA. It was it was technically effective April of last year, but its mandatory use is required by March 20th of this year coming up. So you have about 2 months. Pretty much every CRA, every electronic onboarding environment that I'm aware of has been updated with this information. The changes are so minimal and non-substantial. It's like contact details for some of the entities at the end of the document. But it's going to be tough to argue you didn't have enough time to update your systems, on a technical violation. And there are certain circumstances where the current version of the summary of rights as published by the Bureau has to be provided to consumers. So if you have something in your producer onboarding paperwork, electronic environments, that's called the summary of rights under the FCRA, just contact and make sure those are updated. Now, if anybody's on the line that, partners with my entity, we're not naming names here, but we updated all those a while ago. I'm sure that, Matt, most of these things should be squared away. I just want to make sure it's just some housekeeping. You have until March. It's just swapping out one document for another. So,
And on that note, the industry doesn't change all that often. Here it does, but it's always good to kick the tires. Take a look at your authorization. Take a look at your disclosure. Is it current? Are they on separate pages? Do you have ancillary questions? I've seen so many agent information forms that just go straight on into disclosure, authorization, gathering agent information, and then different disclosures and consents afterwards. And this is a great opportunity. Something is being changed as a requirement. Connect with your CRA. Those that are on the line here, I know are updated, but you should be checking your documents with some frequency. And again, the industry doesn't change all that much, but if you just make a plan, every January or every other year, remind yourself to just validate what you're currently doing is industry standard and compliant. Certainly a good step in the right direction.
So yeah, if unless anyone else has any questions, thank you for attending SILA group. I don't know if you want to sail this out. There's some SILA Foundation. I'll probably try to figure out how to. I saw. Oh wait, we do have some questions coming in.
Yeah,
Matt,
so we copy of the presentation. What are we charging? $5 now? Or?
FCRA says you can charge. No. Yeah, we are going to. I'm gonna send a copy to the SILA group here, and they'll distribute it after the meeting today.
We had another statement rather. So as a Oklahoma licensing regulator for licensing purposes, always recommend referring to the state's background application question to see if they placed time frame on what charges can be admitted. For instance, in Oklahoma, there is no time frame and would accept that a reportable charge should be reported to us regardless of time. So I think that comes back to the point of not asking for something that's beyond the 7 years, but certainly in application, certain regulatory bodies, Oklahoma specifically, FINRA does not have a time frame. If it is a crime, disclosure should be reported. So always weigh that out, as you make that corporate determination. And I think that was it for the questions.
All right.
And we did it under an hour. So
Perfect timing. Perfect timing. Greg and Matt, thank you both so much for sharing your expertise with us today. We always appreciate you and your time. So everybody else, January found us navigating a labyrinth, and February is going to bring us an opportunity to demystify the concepts of compliance and artificial intelligence. And we hope to see you there. Remember that our webinars are free of charge. We appreciate you sharing those invitations. Watch for and complete the post-webinar survey, and we'll see you next month.
Excellent.